Hello everyone, my name is Mark Veloso, a contributor with Litigation Help, and welcome to our video series entitled Case Law Minutes, where we will highlight the most frequently cited family law cases listed on the Ontario Superior Court website. Our video today is on Serra and Serra, decided in 2009 by the Ontario. Please remember that this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. Now, back to Serra and Serra. In Serra v. Serra, the parties were married in 1976. It was not the first marriage for either. The husband owned and operated a successful textile business, and the two lived a luxurious lifestyle, prior to divorcing in 2003. When Mr. and Mrs. Serra first separated, the shares in the husband's business were valued at $9.5 million to $11.25 million. But at trial, 7 years later, his assets had declined in value so that his total net worth was no more than $2 million. The drop in value of the textile business was not the fault of the husband, who had done everything in his power to keep the business afloat. The change was entirely the result of market forces that negatively affected the Canadian textile industry. At trial, the husband sought an unequal division of the net family property under Section 5(6) of the Family Law Act, based on the post-separation date decline in value of the principal asset. Section 5(6) of the Family Law Act allows courts to depart from the standard 50-50 rule and award an unequal division of the net family property if, having regard to the circumstances, an equal division would prove unconscionable. To determine whether a variation in share was justified under Section 5(6) of the Act, the primary issue before the court was whether a post-separation decline in property values could be used to support a finding of unconscionability. This required the court to answer two questions. The first question was whether unconscionability required fault-based conduct from one of the parties. The passage I've chosen to highlight comes from paragraph 47 of the court's decision, where it is stated that, although unconscionable conduct is obviously an appropriate consideration in determining whether equalizing the net family properties would be unconscionable, in my opinion, the true target of the limited exception to the general rule is a situation that leads to an unconscionable result, whether that result flows from the fault-based conduct or not. Having settled that Section 5(6) of the Act does not require fault-based conduct, the court next turned its attention to what exactly constituted, in their previous words, an unconscionable result. In paragraph 47, the court in Serra states that circumstances which are unfair, harsh, or merely unjust do not meet the test for unconscionability. Only circumstances that are so repugnant to anyone's sense of justice or shocking to the conscience of the court would qualify. In deciding in favor of the husband, the Court of Appeal ultimately concluded that it would be unconscionable to order an equalization of the net family properties based upon a separation date valuation of the business, because it would require the husband to make an equalization payment that exceeded his total net worth. The legal rules, or ratio decidendi, derived from the court's decision in Serra v. Serra are as follows. First, fault-based conduct on the part of one spouse is not required to support finding of unconscionability. It is enough that denying the exception to equalization under Section 5(6) of the Family Law Act would have an unconscionable result. Secondarily, circumstances that are merely unfair, harsh, or unjust do not qualify as unconscionable. To cross that threshold, the circumstances must be so repugnant to anyone's sense of justice as to shock the conscience of the court. To learn more about the court's reasoning in this decision, you may access the full case on the Canley website link provided above. Thank you for watching, and I hope you enjoyed this installment in our series Case Law Minutes.